Your Honor, today's date and time set for exam. As you may recall, you authorized Mr. Perry to be allowed to attend inpatient treatment. I was notified yesterday that he was taken to treatment from the jail to Sacred Heart in Richmond. They have informed me that they do not allow Zoom court procedures or any other way to facilitate him being here today. So he is not here. I do have proof of that treatment if you'd like to see it.
No, I believe. How long is
So the program maximum is 30 days. In what they sent me, they said their average time of attendance is anywhere from 10 to 21 days. So I'm not sure exactly. It's going to depend on how well he does while actually in treatment.
Well, why don't I do this? Why don't I adjourn it to my next date, which is the 13th, and if we have to go to another date, we can do that.
That's fine. Mr. Allen let me know yesterday, so I could call off my witnesses.
So preliminary examination in this matter will be adjourned to January 13th, 2026, 9 a.m. That's before me.
Thank you, Your Honor. That's it for me today. So have a happy New Year.
Yes, and to you, sir. Court calls case People versus Corey Curtis.
Good afternoon, Your Honor. Raymond Cook, People.
Good afternoon, Your Honor. Alexandria Taylor appearing on behalf of the defendant Corey Curtis, who's approaching. Mr. Curtis, please state your name for the record.
Corey Curtis.
This is the date and time set for preliminary examination. After conversation with the counsel, we're going to humbly, respectfully request that this court adjourn this exam. There is
Humbly? So that humble was coming from you or from defense counsel?
from defense counsel. She's more humble than I.
Oh, I knew that. That's why I was curious as to where it was coming from. Go ahead.
There's been an offer that was extended as well as some additional conversation as well. One of the people's necessary witnesses for SAS. My understanding is he is away serving in the military right now and could not be present today. He could be present via Zoom if the court would allow that. Otherwise, I expect him to return. I want to say at 1 to 2 months, I believe, is when he was expected to return.
Okay.
So that is correct, Your Honor. We have discussed the date of February 3rd on Your Honor's docket, if that pleases the court.
Man, why are people picking my day? What? Is that my day?
It is actually.
It is? Did you tell him? Somebody gave him my date because it's a secret. Okay, it's not a secret. People aren't supposed to know when I'm here or not. So February 3rd.
Yes, Your Honor.
Yes, please. Thank you.
All right, I'll do it. Only because defense counsel humbly asked.
Thank you, Your Honor.
Preliminary examination will be adjourned February 3rd, 2026, 9 a.m. That is before me.
Thank you, Judge.
Thank you. Bond will continue.
Thank you.
Your Honor, just so that way I'm aware, can I get the Zoom?
Did you just leave and your case isn't over yet? Did you say, ooh, my bad? He said it was? So he just turned his back to me and walked out? His attorney had talked to him about that.
We'll have a discussion.
Trooper says you appear via Zoom. Can I get that Zoom information from Ms. Weidling when we get a little bit closer to that date?
Yes, if it's going to be necessary, certainly you can get that from me and
Thank you.
we'll provide that.
No objection to Zoom.
Very good. Thank you. Now you may go. Court calls the case, People versus Joseph McCalla.
Good afternoon, Your Honor.
Counsel have another one. Did you have another one, Counsel?
She does.
She does.
It's this one.
That one. Oh, okay.
After, okay.
Yeah.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. McCalla. State your names.
Yeah.
Joseph McCalla.
Okay.
Your Honor, the defense said, just in the people are unable to proceed.
And the defense would move to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice on the defendant's motion.
Thank you, Your Honor.
Thank you. Court calls case, People versus Nikita Jackson.
Good afternoon, Your Honor.
Good afternoon again, Your Honor. Alexandria Taylor appearing on behalf of defendant Nikita Jackson, who is approaching. Ms. Jackson, please state your name.
Nikita Jackson.
Thank you.
And Your Honor, similarly on this case, we're respectfully requesting an adjournment. We can get that same date in order to keep the cases together. People would appreciate that greatly.
It does sound humbly. I bet you it counts if she told me, I'd probably feel like really warm. Cook, he just rubs me the wrong way.
I will adjourn. Preliminary examination will be adjourned to February 3rd, 2026, 9 a.m. And that is before me.
Thank you, Your Honor.
Thank you. Bond will continue. Thank you.
Happy New Year.
And to you. Court calls the case of the people versus Raul Fernando.
Andrew Childers appearing on behalf of.
Good afternoon, Judge Aida Sparhich, on behalf of Mr. Raul Fernando, who is approaching and now standing to my right, Judge.
Your name, sir?
Raul Fernando. Thank you.
Today's the daytime set for examination. Is this some people will be moving to dismiss this case without prejudice, file and non-cause?
No objection on our end, Judge.
Case is dismissed.
Thank you, Judge. Happy New Year to you and your staff.
And to you. Court calls the case of the people versus Robert Jameson.
Good afternoon, Your Honor. Raymond Cook, the people.
Good afternoon, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Jameson.
Where is it?
The daytime set for preliminary examination. I believe Mr. Jameson had a PCC earlier today. The court issued a bench warrant. In full candor, the people were not able to proceed today.
In full disclosure to the court, Your Honor, I discovered at about noon that Mr. Jameson actually had gotten released from custody and missed his morning court when I went to try and
Yeah, my
visit
staff was telling you that time and time again, but you weren't listening. But go ahead.
Well, Your Honor, I just wanted to verify it with all the available.
Yeah, no. My staff was telling you. You know, and there's a funny thing. I have the greatest staff in the world. And they tell you something. 99.9% of the time, they're right. You can take it to the bank because, quite frankly, I trust them more than any other people running around this planet. And when they tell me something, I take it to the bank. You might want to learn that, counsel. Bench warrant will issue on this case bond $25,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor. The only other part I was going to add is I also have no contact information for Mr. Jameson. So if he is picked up, I'd ask if the court could, you know, maybe try and get a phone number or something for him. I assume he'll be in custody.
Well, the magistrate, they'll do what they can.
Thank you, Your Honor.
Thank you. Court calls the case, people versus Yasina Miranda.
Good afternoon, Your Honor. Raymond Cook, the people.
Alex Warren Green on behalf of Miss Miranda.
Your name?
Yesenia Miranda.
Okay, I almost got it right. Say it again. the first
Yesenia
name?
Miranda.
Okay, all right. Because everybody's been yelling at me because I mispronounced people's name all day. So I'm a little sensitive.
Your Honor, this is the daytime set for preliminary examination. This time, people are unable to proceed to counts 2 and 3.
The defense would move to dismiss, Your Honor.
All right. Are you moving the remand on counts 2 and 3?
Yes, Your Honor.
All right. Then what I will do.
Miss a date, show up unprepared, or take the court lightly, and everything changes. In this courtroom, respect is not optional, and consequences arrive fast.
I'll continue the defendant's not guilty plea as to counts 2 and 3. Count 1 will be dismissed on the defendant's motion. I'll set a pretrial on this matter.
January 22nd, Washington.
January 22nd, 2026. It's at 9 a.m.
Yes.
9 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case, people versus Derek Shipman.
Brian Bowling on behalf of Mr. Shipman, who's approaching, Judge. Hey, Derek, state your name.
He knows it.
Derek Shipman.
Thank you.
Judge, we have a resolution in this matter. There should be a signed plea form in the court file as well as a signed advice of rights. Or a advice of rights I signed on Mr. Shipman's behalf with his consent.
All right. The plea form indicates that the defendant is going to be pleading no contest. Did I get this, please? Yeah, I did. No contest to 3 charges. Count 2 of operating while intoxicated, the 93-day offense. Count 3, driving while license suspended, 93-day offense. And count 4, disorderly person, a 90-day offense. Upon his successful plea to those charges, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's my understanding as well, Judge.
May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name, please.
Derek Shipman.
Sir, it is this court's understanding that you're going to be pleading no contest to 3 charges. So,
Yes, sir.
understanding?
Yes.
First charge is count 2 of operating while intoxicated. That's a misdemeanor punishable by up to 93 days in jail, a $300 fine plus, or I'm sorry, a $500 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order your vehicle forfeited, or could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes.
All right. Count 3 is the offense of driving while license suspended, denied, and or revoked. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. You understand that, sir?
Yes.
And count 4, disorderly person, is a misdemeanor punishable by up to 90 days, $500 fine plus court costs. You understand that?
Yes.
All right. You understand what a no contest plea is?
Yes.
All right. 2 things about it I have to make sure that you understand. First thing is that it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
And you understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court.
Yes.
All right. Or her successor, I should say. Still wish, and the basis for the no contest plea count.
Lack of recollection, Judge.
All right. Still wish to plead no contest, sir?
Yes, sir.
To the charge of operating while intoxicated, how do you plead?
No contest.
To the charge of driving while license suspended, denied, and or revoked, how do you plead?
No contest.
And to the charge of disorderly person, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form or had an advice of rights form signed on your behalf?
Yes.
All right. Any questions regarding any of those rights?
No.
You understand that by pleading no contest, you're waiving or giving up the rights on that form?
Yes. Oh, excuse me. Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
Yes.
Okay. Were you on probation or parole at this time?
No, sir. No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily
Yes.
and of your own free will?
Yes.
All right. Court has been provided and has reviewed Ann Arbor Police Department report for their case number 243152. Any objection to the court having reviewed that report?
No objection.
No objection for the defense, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence evaluation and recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have...
I'm not aware of any, Judge.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
So is the defense, Judge.
Court will accept the defendant's no contest pleas to counts 2, 3, and 4. Count 1 is dismissed. A pre-sentence investigation and report is ordered, as well as screening and assessment at 15th District Court Probation. Sentencing in this matter will be January 20th, 2026. What time? 9 a.m. Before Judge Valvo or her successor. Bond will continue.
Thanks, Judge. Thank you, sir. Happy New Year.
And to you, sir. Court does call the case, People versus Abbas Safadine.
Andrew Childers, appearing on behalf of the people.
Good afternoon, Your Honor. Jonathan Sachs for Mr. Safadine. Boss Safadine, Your Honor.
Thank you. All right, what are we doing?
We are here for a negotiated guilty plea.
All right, I have a plea form before me indicates that the defendant will be guilty to the charge of larceny by false pretenses under 200, 93-day offense. Upon a successful plea to that charge, count 1 would be dismissed. There is also the agreement that the prosecutor will recommend or is okay with the height of sentence, and restitution is agreed at $500.
That's correct, Your Honor.
Okay, the sentencing judge waiver box is not checked, but I view that as an oversight, so I'm going to check that box.
That is purely my oversight, Your Honor.
May I have him sworn?
Raise your right hand. You solemnly swear in the following testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Boss Safadine.
All right. So it is this court's understanding that you are going to be pleading guilty to the offense of larceny by false pretenses under $200.
Yes, Your Honor.
That is a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property, which is the subject matter of the false pretenses. If that's greater than $500, that becomes the maximum fine. You understand that?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge in this matter, and you would be sentenced before Judge Perry in the 15th District Court.
Yes,
You
Your Honor.
understand that?
Yes, Your Honor.
Understanding all that, still wish to plead guilty?
Yes, Your Honor.
All right, and to that charge, how do you plead? How do you plead?
What do you?
Guilty or not guilty?
Oh, I plead guilty.
Yeah, right. You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct, sir?
Yes, Your Honor.
Any questions regarding those rights?
No, Your Honor.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No,
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of this offense?
Yes, Your Honor.
March 16, 2025, at the location of 516 East Liberty Street, City of Ann Arbor, Washtenaw County, State of Michigan. What'd you do regarding, well, what'd you do that makes you think that you're guilty? Let's do that.
I used the card that was not mine to pay for the parking structure.
To do what?
To pay for the parking structure.
Okay. So the card was not yours?
Yes. Without
You didn't have the owner or device holder's permission to use it?
No, I just did.
And you did not inform wherever you were using it that you didn't have permission?
No.
Right? And because of your use, you obtained goods or services?
No.
You didn't get anything?
No.
What happened?
Your Honor, it was rejected, but he still used the financial transaction.
Got it. Okay, but he didn't get anything from it?
No.
Okay, then I'd have to certainly take it as to the higher charge, which is actually the use, because there was no value done. Okay. Sir, if I accept your plea, I do have to advise you that between the time of my acceptance of your plea and your time of your sentencing, that if you commit misconduct as defined by the Michigan court rules, that number one, the court would not be bound by any evaluation and or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea count 2, particularly under the higher offense version. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be January 30th, 2026, 8:30 before Judge Perry.
Your Honor, is there any chance of another date? I'm looking forward to being right here on January 30th at 9 a.m.
Oh, I'm sure there's, another day. I don't have it. So what you can do is I have to give you this date. You can contact 15th. They'll be more than happy, I'm sure, to accommodate another date for you.
All right, thank you.
Thank you. The court, for its part, also does not believe there's a conflict either in the Michigan courtroom, so the case is decided thereunder to the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people versus Jason, is it Elk? It's you. Oh, come on up. Who's your attorney? Mr. Goldman. He stepped out. All right. Well, I'll pass it. Okay. Court does call the case of people versus Reginald Sims.
They also stepped out.
Good morning. Okay, so I'll pass that one too. Third time's a charm. Court calls the case people versus Chanel Griffin. Miss Pate is here, and I think your client. You see that? I was asking you, and he just decided to talk. Court calls the case people versus Jason Eckel. Should have heard. I know you're ready. You should have heard what your client said. I don't know why he's not here. It was horrible.
Good morning, Your Honor. Robert Goldman, P81222, here on behalf and alongside Jason Eckel, president of the courtroom this morning. Mr. Eckel, would you please say your full name for the record?
Jason Michael Eckel.
All right. Thank you. All right. What are we doing today?
Your Honor, this is a date and time set for a sentencing hearing in this matter. I've had an opportunity to speak with the probation department in this case. Your Honor, a plea was conditioned on Mr. Eckel being admitted into the sobriety court. Mr. Eckel did screen with this court's probation department. Ultimately, on Friday, we were advised that he was not accepted into this court's probation sobriety court program. However, having spoken with Ms. Pilara, it is the understanding of the parties that we would be asking for an adjournment today for purposes of screening with the either 15th District Court or another Washtenaw County District Court for purposes of admission. We do think that Mr. Eckel is a good candidate and can be admitted. So for that reason, we are still seeking admission as we believe that the ultimate benefit of the program warrants seeking an adjournment at this time.
Check, right, Ms. Pilara?
Yes, Your Honor. I did learn on Friday from the 14A sobriety court that he was not accepted. I did speak with counsel and indicated to him that there is 2 other options in the county that he could try to get into their program. I know that Mr. Eckel did have a couple of appointments in those with ours, and they kind of got bumped down the line. This is why it had to be adjourned. My concern is, and speaking with counsel, this plea was taken with the agreement, is how I read it, that it's kind of contingent upon him participating in the sobriety court. So I would like the court to give this defendant the ability to try to get into one. He did follow through with the screening process. Any delay in that fashion was not on the defendant.
Okay, and I would just indicate, because people have said it different ways, I don't read the plea form that his plea was contingent upon that. What it was is the defendant pled and agreed to enter into the participate in sobriety court. So
I don't think it would be a failure of the plea if he's not accepted.
Okay.
Okay, because I think if it were conditioned on that, that would be something different, but I don't read this as saying that he's just agreeing to go in. If they say no, then we've got to figure out something else to do, but, all right. November 16th, December 6th, December 7th. What happened with your testing?
Your Honor, having spoken at length with Mr. Eckel regarding it, those 3 dates, if you notice the times specifically for those 3 out of his windows of the day total, they all occurred when Mr. Eckel was at work. Mr. Eckel does work within the engineering maintenance department of a hotel. The windows that he was just slightly delayed from submitting his test within occurred during times where he was engaged physically in his work. He did then go get his device immediately as soon as he was available. I think his tests are all within 10 to 15 or so minutes of that. We have spoken regarding the need to ensure that it is timely, not just submitted at the about the window. Fortunately, the tests all do come back as negative to verify that he was not consuming. We have spoken. He is going to make additional efforts. For the court's understanding too, I think it's important, as Mr. Eckel advised me, within where he works, there's not a locker or a safe storage area where he can keep his device free from access to others or tampering. So he does have to keep his device in his vehicle. So as soon as he completed an assignment he was working on, he'd go get it, albeit, as the court can see, about 10 or 15 minutes after the window closed.
Well, no, it's not 10 or 15 minutes. He was half an hour late.
Oh, I'm sorry.
Yeah, it's okay. Same point. I get it. All right. All right. Just try to make sure you do it within those windows. Okay. The defendant is to seek an alternative sobriety court, either 14B or 15th, which may be available. You live in Ipsy though, so maybe 14B might be a shot he could take.
Yeah, we were going to kind of explore both simultaneously. He does work in Ann Arbor, very close to the 15th District Court. So we were thinking that for review hearings, that might be even more accommodating with his schedule to ensure he can maintain employment and his obligations under the program. We were going to be speaking with both of the courts to help determine which is the most appropriate.
Okay. I'm just thinking as the new sobriety court came in that, well, anyway, I'm going to adjourn the defendant sentencing to January 28, 2026 at 12 p.m.
Thank you, Your Honor.
Okay. All right. Thank you. Court recalls the case People versus Reginald Sims.
Good morning, Your Honor. Justin Zaid, appearing on behalf of Mr. Sims, present standing to my right. State your name.
Reginald Sims.
Your Honor, date and time set for sentencing. We did have an opportunity to review the report. We believe it to be accurate. No additions, corrections, deletions. If I just may allocate on my client's behalf.
Yeah, you may.
I know that based on your tone, I think that I think you know what we need, what else we need to address.
Yeah.
If you would prefer that we address the bond violations first.
We might need to.
Okay.
Do that, but
certainly.
either way, whatever.
Well, we could start with that. That's fine. We were given the bond violation report. I did have an opportunity to review with Mr. Sims. We went one by one, Your Honor. I understand that the court might have concerns that it looks as though there's some type of pattern of disregard for this timing. And what we would submit to the court is that Mr. Sims has been on this device for about 4 months now, about 120 days, testing 3 times a day. I'm no mathematician, but over 360 tests, I believe. What you see in front of you, I believe, is the extent of the late tests. I believe that there are several late tests, some of which are right outside the window, some a bit delayed. Of course, there's no excuse, no justification for it, but to provide a little bit of context, Mr. Sims works overnights. He works at Ford. And so those tests primarily in the middle of the day would be when he's sleeping. He usually wakes up about 30 minutes before his 6 p.m. shift. And so he found himself having issues. We discussed how of course, we would have been more proactive, brought this issue up. prior to getting this bond violation report so that we could find a schedule that would be more conducive with his work schedule, testing schedule, I meant. That being said, I don't think he's had a single positive test since he's been testing, whether before this, after this, at any point in time. I think he's demonstrated that he takes the court's orders extremely serious, albeit with some hiccups here, but nevertheless stands before you taking accountability for those, and is intent on demonstrating to the court, as he's already done for himself and his family, that he's going to abstain from alcohol.
When I look at this though, I mean, it's a 3-hour window and I'm unclear as to why he can't get himself in that window on numerous occasions. I've got 1, 2, 3, 4, 5, 6, 7, 8 missed windows. I mean, in some, he's up to an hour late in terms of testing.
5 in the morning, there's 2 tests, 6 to 9, and yeah, so it's 2 months.
Yeah, so Your Honor, he's working 6 p.m. to 5 in the morning. So basically he gets home and gets testing windows about an hour later. So he's basically got to fight to stay awake. And then sometimes, again, it's no excuse, but he falls asleep. And so before that 6 a.m. window starts, he gets home at about 5:15, and he's basically got to fight it for 45 minutes to stay awake so that he could submit to it. Sometimes he misses that. And then the 12.
I get that, but there's only one of the tests that's a 6 a.m. test.
And then still
12 to 3 is the next one.
And then the next one's 12 to 3. And then he's saying he sleeps during that, gets up at around 5 p.m., gets ready for work and goes to work.
So I get that. So then why is he missing his 9 p.m. test? Which are 3 of these.
Your Honor, I know of one time I traveled and didn't get there to 12:07. Maybe it's something like a 12:04, 12:07. The other 2, I'm going to honestly say machine. I work, and I usually do that on my break. I'm at work at that during the 9 p.m. to midnight. So I've taken it every time, in my opinion. However, I did notice once or twice that it called for a late register. It said it did not, and I assumed or thought I did. So I do the thing all the time. Is, you know, like I say, I work, I'm asleep during the 12 p.m. to 3, and I've missed that a few times because I just wake up 15, 20 minutes behind, so forth. But then I'm taking the test, Your Honor. I don't drink.
I mean, I hate to do this, but because if I mean, the cold-hearted reality is that these are really violations of Tether. May say there's no distinction between that and drinking, but certainly the court could treat it that way. Is a Scram Tether going to work better for him? For the 30 days that he's going to be on something?
What do you want to say? Your Honor, let me say, I'm also a coach, so there have been a few times where I was either with the kids or the parents, and you know, I'm always trying to break away, and so I can't do that. So there has been a few times where I'm in the midst of school administrative stuff because I got to blow up between the 12 to 3, and I try to get, you know, and that you can see that they're just a few minutes behind. But I participate as a coach also at Belleville. I'm a coach and for 20 years, and so I am a part active as well as working, and I'm trying to make that time. There are only times.
Well, but you've got to make the time.
I have been.
Otherwise, what's going to end up happening is I'm either going to have to incarcerate you, or I'm going to put a Scram Tether on you, which in dealing with the kids, and I see that is going to be probably more problematic in terms of what you'd have to explain to them.
Your Honor, when you look at the report, it recommends basically giving him an audition here. 30 days, get it right, or he has no excuse. I think that that's fair and appropriate. I've impressed upon Mr. Sims the importance of showing the court 30 days without a single violation. I think we would respectfully request the court adopt that, give him an opportunity to prove that he's going to be intent on getting it done.
Let me just say, there's a 3-hour window. And you just don't have to wait to the end of that 3 hours. You just have to do it within that 3-hour window. So in that respect, you really shouldn't be missing it. Okay, you just have to find time within that 3 hours to do that. All right, am I understood?
Understand.
Go ahead, Council, as to sentencing.
Well, I just briefly alluded to one of the points was that 30 days on the sober link. I think, again, based on everything we just discussed, I think that's fair and appropriate. We'd ask the court to adopt that. As it relates to the impact panel, we did tender proof of completion to probation, that has been completed as well. I understand that they are recommending in the alcohol education program. I think that given what I know about Mr. Sims, that would indicate that he can complete that program and move forward with this. Otherwise, we think that the report and recommendation is fair and appropriate. Ask the court to adopt it.
All right, sir, is there anything you want to say before I impose sentence?
Yes, Your Honor. Once again, I've been a standing citizen. Not only did the court have to give me a penalty or to say I had to do the breathalyzer, I did not drink. I have not drunk since the day of my accident. I want to take responsibility of that. Due to leadership, I'm part of the, I lead kids around and coach and things like that. So I have to make an example for myself as well as others. So yeah, the Tether, things like that. Yeah, I'm a good citizen. So I don't want to be explaining to these kids, like, you know, the breathing. Like I said, I had to run out and do those things. I couldn't do that openly, but, you know, doing positive things, staying active, and, you know, I just work, stay active with the children and spend time with my grandkids. So I follow your system. I believe. I apologize for the times that I was late. However, I was just late, you know, based on activity and or sleep. But I respect the system. I apologize for being here, wasting everyone's time. And I'd like to move forward with you on good behalf.
Who's here with you? Who?
My missus.
Should say that louder.
I didn't.
You like whispered it, like.
Oh no, I didn't think
you didn't want anybody to know. I figured that was
no.
It was.
She's here.
Ma'am, you want him back?
Yes, but I'm tired of talking remind.
Ah, see, I knew. That's why I wanted to talk to her, because she looked responsible. Like, you know, you're talking about what a good and upstate citizen, and I'm not disputing that, but I think somebody helped you get there.
I sleep during that time period, Your Honor. So
well, hold on.
12 to 3.
Hold on. See, why are you talking? She just told me that she's trying to remind you. She's sick and tired of having to remind you.
Understandable.
Right?
Yes.
So, and all that really tells me is that at times, your husband is just not listening. She's trying to get you to do the right thing and follow all along. Am I right, man?
I agree, yes.
Yeah, okay. See, she's still trying to save you. All right. Listen to her.
I do.
She'll make sure that you'll get this done so you don't end up in trouble. You hear me?
Yes, sir.
I guess if she wants you back, I'm not going to stand in the way of that. Court does acknowledge this is not a serious misdemeanor as defined by statute, however, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of alcohol. Tell him not to do that. Alcohol highway safety education program and abstinence from all intoxicants for a year. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It's therefore the sentence of the court. I'm going to place you on probation for a period of 12 months. An order $855 fines and cost, $100 prosecution recovery cost, $100 police agency recovery cost, $360 probation oversight fees. When can you pay that?
Within 30 to 45 days, Ron, I'll put that.
Pardon?
30 to 45 days. Month.
You ask the person in charge when you could pay it? Or are you just making that up?
I just know I'll put
Ma'am, when can he get this paid? In a month.
The next month's budget.
Well, no, you know what? You just,
The boss has
you
spoken.
need to stop talking. I just went to the brain trust. I got it. She, in a month. So by January 30th?
Yeah.
Thank you, ma'am.
He blamed work and sleep the judge cut through it. Fast, make the time, or you're going in.
I would imagine every time you started thinking on your own. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the Alcohol Highway Safety Education Program. You're to provide proof of the victim's impact panel attendance to probation. That has been completed. I'm going to continue the Sober Link for an additional 30 days in lieu of 5 days in jail. Order 93 days in jail suspended. Sir, one thing about me is I've got a very good memory. And your wife told me she's reminding you. So if I have a missed test, late test, anything like that, that means that you're not listening to her.